Are you confused about what California landlords can legally do and what crosses the line? If you're done guessing and want answers that actually match today's laws, you're not alone. In this update to our popular video, I'm going to show you the newest do's and don'ts that every California landlord and renter needs to know to stay out of trouble. Let's start with the 3 things a landlord cannot do. Number 1, a landlord can't reduce services or turn off utilities even if the tenant isn't paying rent. I had a client in this exact situation. The renter had stayed beyond a valid 60-day notice, wasn't paying rent. To make things worse, a winter storm was rolling in, and just then the water heater broke. Even though the renter was being evicted and not paying rent, the landlord still had to send out a plumber to replace that water heater. Why? Because the landlord must continue to maintain habitability even if rent isn't being paid or an eviction's underway. Other examples: can't change the locks, turn off the water, take away a parking spot, or remove the front door to the property. I hear this all the time from landlords who give me a call or shoot me an email, and renters as well, and they say, my landlord's kicking me out because they're selling. Number 2, a landlord can't terminate a tenancy just because they want to sell the property. Here's the truth: selling is not a valid legal reason to terminate a tenancy in California. There are certain valid reasons to terminate a tenancy, but selling is not in the list. Some properties are exempt from special protections under the statewide Tenant Protection Act. We've released videos on that. But generally speaking, the sale of a property isn't an excuse that can be used. So what paperwork can landlords use if they do want to terminate a tenancy? Number 3, landlords can't make up their own notices or use homemade forms. California has specific state or local mandated languages for notices, leases, 3-day pay or quit paperwork, etc. And you can't just Google it up like my son Liam likes to say, or draft your own version and expect it to hold up in court. And there's a proper legal way to deliver that proper legal paperwork. If you hand your tenant a handwritten note or send a text or send a screenshot, it won't hold up in court. No emails, no texts, no screenshots. If it's not served the legal way, that notice doesn't count. Now that we've covered what landlords can't do, let's flip it around. Here are 3 things that landlords can legally do that may surprise you. Number 1, a landlord can terminate a tenancy without giving any reason in certain cases. If property is exempt from the statewide Tenant Protection Act, again, we've done videos on that, and there's no local rent control ordinance as well, for certain properties, a landlord can serve the correct notice and simply end the tenancy. No relocation assistance and no specific reason given. The key is that the property must truly be exempt from the statewide law and local rent control laws, and the landlord must have provided the proper disclosure paperwork to the tenant. The next one is one of our more common questions: can a landlord enter my rental unit? Imagine a landlord needs to check a smoke detector and they've given the tenant proper written 24-hour notice. That's perfectly legal, as long as the landlord gives the legal notice and the entry is for a valid reason, like showing the property to a prospective buyer, checking smoke detectors, inspecting water heater straps, showing to contractors. Those are allowed reasons. If there's an emergency like a burst pipe or leaking water heater, the landlord doesn't need advance notice to enter, but it must truly be an emergency. And yes, it's true, a tenant can be evicted if they refuse lawful entry after proper notice has been given. And how about rent increases is another question we get often. Number 3, a landlord can raise the rent even if they haven't made any upgrades like new carpet or paint or any changes to the rental unit. As long as the tenancy is month to month and the increase follows the proper limits and notice periods, that's a perfectly legal rent increase. For increases of 10% or less within 12 months, landlords must give 30 days notice. If the increase is over 10%, it's a 90-day notice. Now bear in mind that local rent control laws like Los Angeles's rent stabilization ordinance may have a lower increase amount. So make sure if there's local regulations that you know what those are, but landlords aren't required to renovate or make any improvements before they do a rent increase. Let us know in the comments below what we need to add to our 3 things landlords can do and 3 things landlords can't do. Your story may help someone else avoid a major issue or mistake. If you found this video helpful, you're not going to want to miss our weekly email newsletter. Make sure you're signed up for that. And speaking of not missing, you're not going to want to miss this next video right here.